Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy, popularly known as AAA. This is our 53rd lecture series. This is pertaining to landmark judgment, that is serial number 84, ALIGARH Muslim University versus Naresh Agarwal. So this is the case which we are going to deal with in detail, but it is our regular practice that we recite the preamble of the Constitution. We strongly believe that preamble our goal and preamble our soul, because whatever the objectives, whatever our founding fathers dreamt about our country, it is being reflected in the preamble. So therefore it is our bounden duty to remember, to retain and apply in real terms. So I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Dear friends, we have gathered here to discuss about a landmark judgment, and it falls under the revised leading cases and one of the important subjects for the AOR examination. So what do we learn from the leading case? Why it was prescribed as a subject? From the leading case, what we learn is firstly the facts of the case and how the law is being applied to each case, and how the law is evolved, how the statutory provisions and the constitution provisions are interpreted, and reasons to their decisions, and finally what is being overruled or what is ruled. And it acts as a precedence. Every landmark judgments are the precedents, and they lay down the law for the remaining country to follow. Article 141 of the Constitution of India, where this specifically deals with the law declared by the Supreme Court, is binding on all the courts within the territory of India. So therefore, dear friends, we are all aspiring to be an advocate on record, and you wanted to practice more specifically in the Supreme Court. So it's a privilege to be an advocate on record, to assess the Honorable Apex Court, to lay down law for the country. So the more you prepare well, the more you can assist effectively, and the well-written judgment comes from the well assisted by the advocates. So therefore, it is our endeavor to understand how our forefathers, how our eminent senior advocates, they have assisted the honorable judges to deliver the landmark judgments. Every landmark judgment has got its uniqueness, and we should understand that, and we should appreciate effectively, and each word has a depth meaning. So therefore, let us understand why this ALIGARH Muslim University is kept under a landmark judgment. That is very important. So I would like to discuss this topic under 5 headings, dear friends. So the first heading is, please make a note. Reason is, you should not feel that you will make a note after watching the video. You should make notes now. If there is any difficulty clarification, you can watch those videos. Just don't miss this opportunity. Utilize this opportunity in a very good manner, effective manner. So the first heading is background of the case. The second heading is issues involved. The third heading is decision of the Supreme Court. What is the majority? What is the minority? Is there any split up or unanimous? Fourth is reasons for the decision. Fifth one is conclusion. Under these headings, I will be dealing with this topic. Firstly, the lecture number 53 will be dealing with first 3 headings, that is background of the case, issues and decision of the Supreme Court. Lecture number 54, we will deal with reasons for the decision and conclusion. Both lecture number 53 and 54 will be dealt today itself. Now coming to the background of the case. If you look at the name of the case itself, ALIGARH Muslim University. So therefore, it revolves around the Muslim University. What is the background of the case? Let us understand, dear friends. On 8th of January 1877, 8th of January 1877, Sir Syed Ahmad Khan established Muhammadan Anglo-Oriental College. I repeat, Muhammadan Anglo-Oriental College, in short MAO, in ALIGARH in the year 1877. There are many dates, but I want to bring it to your notice the material facts and events alone. Thereafter, in the year 1920, where we were all ruled by the Britishers, we got independence only in the year 1947. So the British government passed an enactment called ALIGARH Muslim University Act 1920. So in the year 1920, the act was passed. The name of the act is ALIGARH Muslim University Act 1920. Now the next year is 1950, 1950, where our Indian Constitution, Constitution of India, was adopted in the year 1949 and enforced in the year 1950. In this case, we will be dealing more particularly with Article 30, Clause 1 of the Constitution of India. The next date year is 1967. 1967. In this year, what has happened? A constitution bench judgment was pronounced in this year 1967. The name of the case is, please note down this case, because the landmark judgment which we are discussing now, ALIGARH Muslim University, was decided by 7 judges, questioning the correctness of the decision rendered in this 5 judges case, that is S. Ajit Basha, AZWEZ Basha versus Union of India. Ajit Basha versus Union of India. It is reported in AOR, All India Report, 1968, AOR 1968, Supreme Court, SC 662, page number 662. In this case, the Honorable 5 Judges bench, they have held that ALIGARH Muslim University was not a minority institution. ALIGARH Muslim University was not a minority institution. Why? because according to the Constitution Bench judgment, the ALIGARH Muslim University was incorporated, was established by virtue of the statute. In the year 1920, ALIGARH Muslim University Act was enacted. So according to this Aziz Basha case, the honorable judges have held that this is born out of the enactment. Therefore, this will not fall under a minority institution. The second ground for deciding that it is not a minority is it was not established and administered by a minority community as required under Article 30 Clause 1 of the Constitution of India. So these were the two reasons, main reasons for declaring that ALIGARH Muslim University was not a minority institution. So this was the law in the year 1967 was declared by the Honorable Supreme Court. Thereafter, on 26th January 1981, on 26th January 1981, Republic Day, a two-judge bench of this court, two judges of the Honorable Supreme Court, the name of the case is Anjuman -E Rahmania versus District Inspector of Schools. I repeat, Anjuman E Rahmania versus District Inspector of Schools. In this judgment, I repeat dear friends once again, Anjuman E Rahmania versus District Inspector of Schools. In this case, two judges of the Honorable Supreme Court had doubt in their minds about the correctness of the judgment rendered in Aziz Basha case. So when they have a doubt, they cannot overrule the 5 judges bench. US division bench is bound by the 5 judges bench, Constitution bench. Therefore, they have requested the Honorable Chief Justice of India to constitute the appropriate bench to decide this issue, whether law laid on in Aziz Basha was correct or wrong. So that was referred, and finally the matter was placed before the 7 judges bench. Why 7 judges bench? Because Aziz Basha was comprising of 5 judges. When the correctness of the 5 judges has to be done by the 7 judges bench, therefore matter was referred to the 7 judges bench. So that was kept pending. In the year 2005, now I am moving on to the next year, 2005. In the year 2005, there was a challenge with respect to the reservation of 50% for Muslims students in ALIGARH Muslim University in their post-graduation for medical course. So that was challenged before the Allahabad High Court in the year 2005, that they cannot reserve 50% for Muslims. The single judge of Allahabad High Court has declared that it is not a Muslim university by following Aziz Basha case. Therefore, reserving 50% for Muslims is incorrect, because the single judge of the Allahabad High Court has followed the law laid down in Aziz Basha case. Thereafter, the matter came up before the Supreme Court. ALIGARH Muslim University came up before the Supreme Court. It came up before 3 judges bench. His Lordship, former Chief Justice, Justice Ranjan Gogoi, led the bench. And it was brought to the notice of 3 judges bench by saying that already the matter was pending before the 7 judges bench. Therefore, this matter should also go before the 7 judges bench. So that is how the 3 judges bench also referred the matter to the 7 judges bench. So finally, E. Rahmania case, Anjuman E. Rahmania case also referred the matter to 7 judges. Now, the appeal arising out of Allahabad High Court was also referred to the 7 judges bench, questioning the correctness of judgment rendered in Aziz Basha case. So this is how the matter came up before the 7 judges bench, and this is the factual background of the case, dear friends. Now the second issues, now moving on to the second heading. The second heading is issues involved. So what are the issues that was under consideration by the 7 judges bench? The preliminary objection was the referral by 2 judges directly to 7 judges bench is incorrect. The referral itself is incorrect. That was the objection taken by Union of India. According to Union of India, the 2 judges cannot refer the matter to the 7 judges bench. So it is somewhere out of context, violation of judicial discipline. Therefore, the referral itself wrong. That was their preliminary objection. Second issue is, what are the principles, or what is the test to determine whether ALIGARH Muslim University is a minority institution or not? So to attract Article 30 Clause 1, which guarantees special rights to the minority institutions, how to get the protection under Article 30 Clause 1? So what is the test? Number 3, whether Aziz Basha case laid down a correct law, or does it require reconsideration? So testing the correctness of the law laid down in Aziz Basha case. So these were the issues that was under consideration by the 7 judges bench, dear friends. This judgment was really running to 501 pages. But for the purpose of an advocate on record examination, you cannot write entire aspects. So what is important? What is crucial? This is like a juice out of the fruit. So therefore, you have to just at least learn these aspects, very crucial aspects. Now coming to the third heading, dear friends, that is decision of the Supreme Court. Here I said the bench was comprising of 7 judges, but there was a split, majority view and minority view. Minority view, we will be discussing it in the later session. Majority view, 4:3. The ratio is 4 majority, 3 minority. In the majority, the author of the judgment was Honorable Chief Justice of India, former Chief Justice of India, Dr. D.Y. Chandrachud. His Lordship has authored the judgment. So this is the decision of the Supreme Court. So with this, we will conclude the first portion, that is lecture number 53.